Good afternoon, everyone. This is Samantha from the Law Offices of Samantha Wolfe, and thank you so much for joining us for this month's virtual seminar. We try to do virtual seminars every month, and then we upload our videos to our website and our YouTube channel. So if you enjoy this one after watching it, feel free to jump over to our YouTube channel and you can find a whole bunch of other videos that we've done on other topics. Today, I'm excited because we're going to talk about something I don't think we've ever done a presentation on this topic today. It's going to be about blended families. So let's go ahead, Jess, and let's share our screen so that we can talk about blended families in the context of estate planning. Okay, so today we're going to talk about estate planning for blended families. We're going to be addressing unique challenges with legal solutions. It seems like when we're meeting with clients, we're finding more and more families where they might need different or customized estate plans based on the different family members that they want to provide for. And in that context, it does seem like blended families is one area where we are a little bit more creative with our estate planning. So just like we start every seminar, this is our mission statement. We always like to start with our mission statement just to explain why we do our virtual seminars. We feel like educating our clients and referral sources is always part of our job, and we're happy to do it. So today's objective with discussing blended families is to provide guidance on addressing the unique challenges faced by blended families in estate planning, ensuring fairness, reducing disputes, and complying with Pennsylvania law. What is a blended family? This is where we might have children from a previous relationship. It might be a second or third marriage, or it might be a non-traditional family structure. I met with a client a couple months ago where it was actually the grandparents who were raising grandchildren. They had adopted their grandchildren, and so that was a unique family situation that we don't see every day. Challenges that might be happening when we deal with blended families would be balancing the interests of biological and stepchildren, especially if it's a subsequent marriage later in life. A lot of times we have clients that have adult children from either previous relationships or previous marriages. So we want to make sure we're addressing that challenge in a way that makes sense for both sides. It also means that we might be addressing potential conflicts between the surviving spouse and the children from a previous marriage of the other spouse. So we want to make sure that we're addressing that too, because it seems like in most of the clients that we meet with, they do want to provide for their surviving spouse. It's not that they want to cut their surviving spouse out completely from their estate plan, but they just might want to provide some guidance when the surviving spouse dies about where they want their assets to go so that it's not necessarily going outside their family line. And then the last challenge that we typically see would be if we have spouses that each have a will, because every individual needs a will, if they aren't mirror images of each other. A lot of times our married couples don't realize that if you have jointly owned assets, or if your will pays everything over to your surviving spouse, and your surviving spouse's will is different than yours, then you've basically cut out your beneficiaries. Because if your surviving spouse doesn't have the same provisions, maybe they're providing for their children, then you may have inadvertently cut out your own children or your own beneficiaries. So when I see married couples, a lot of times they have to explain that you're each going to have a will, but those will provisions are going to be mirror images of each other. So that way it doesn't matter who dies last, we can make sure that both spouses' estate plan is being fulfilled. Why is estate planning critical for blended families? So the first reason is protecting assets for those intended beneficiaries. Secondly, we want to make sure we're avoiding unintended consequences under Pennsylvania intestacy law. And then lastly, we want to make sure we're maintaining those harmonious relationships with those family members. I'm a visual person, so this is a visual that shows the intestacy distribution in Pennsylvania. And what is often shocking to clients when we meet with them is that if you do not have a will, and you are married and you have adult children, whether it be adult children from a previous relationship or even adult children of your current marriage, it then in essence divides the estate so that your spouse doesn't receive anything. So a lot of times we have married couples that are going to want to do wills because they actually do want everything to pay to their spouse. And under Pennsylvania intestate law, it doesn't automatically pass to the spouse. So this is a chart that explains that. So if you die with, and then straight down from that is if you die with spouse and descendants from you and someone other than that spouse, then your surviving spouse inherits 1/2 of your intestate property and your descendants inherit everything else. If you go one box over, if you die with a spouse and descendants from you and that spouse, then your spouse inherits the first 30,000 and then 1/2 of the estate and your descendants inherit everything else. So that's a common situation where, again, Pennsylvania doesn't assume that you like your spouse enough that you would want your estate to go entirely to your spouse. So you want to make sure that if you want it to go to your surviving spouse, that you have a will that states that. Now, if you actually start in the center and you go one box to the right, and it says if you die with spouse and parents, meaning that you don't have any children, but you do have a spouse and then surviving parents, that spouse inherits the first 30,000 of your estate plus 1/2, and then your parents inherit the remaining estate. So again, even if you don't have children, if you're married and you want everything to go to your spouse, you're going to need a will. This is just a chart showing the same thing. Sometimes people prefer the visual, sometimes people prefer the chart. So this is just the same information showing that. The spousal elective share, what this is talking about is in Pennsylvania, a surviving spouse does have the right to claim an elective share of the decedent's estate instead of what might be left to them under a will or trust. So again, Pennsylvania doesn't assume that you like your spouse. So sometimes what will happen is that people don't really like their spouse, and so they don't want to provide for their spouse, but they're still married. They haven't filed any paperwork to dissolve the marriage. And so your spouse has two options. Either they can receive assets under the will if they're listed, or if they're not listed but they're still married to you at your death, they can claim the elective share. And usually they're going to claim whichever gives them the higher amount. So typically the elective share is about 1/3 of the decedent's probate and non-probate assets. Now, that being said, there are some assets that are not subject to the elective share, and we have some later slides that describe that. But just know that generally it's about 1/3 of your assets, taking into account those accepted assets. The purpose is to protect the surviving spouse so that they can't be disinherited. So again, unless you have something in writing like a prenuptial agreement or a postnuptial agreement that says that, hey, we're not going to provide for each other, Pennsylvania is saying that your spouse can either receive assets under the will or claim the elective share. That way you can't completely disinherit them. You do have to claim the elective share within 6 months of the decedent's death or the probate filing. And the effect on the estate plan is it does override the terms of the will or the trust for the spouse's share. So again, if you're thinking of disinheriting your spouse, but you're still married and you aren't filing for divorce, you have to consider the fact that your spouse may claim the elective share and still receive about 1/3 of your estate. This is the Pennsylvania statute talking about the elective share, and it talks about property that's subject to the election. So this would be property passing from the will or intestate law. And it goes on to talk about other things that would be subject to the elective share. Now, I think what's more important is what assets are not subject to the elective share. So this is the next slide. So this assets that are not subject to the elective share would be any conveyance made with the express consent or joinder of the surviving spouse. So if you, for example, file or make a gift and file a gift tax return, a Form 709, and you and your spouse are splitting those gifts, that property is not subject to the elective share. Secondly, proceeds of life insurance, including accidental death benefits on the life of the decedent, not going to be subject to the elective share. The other big asset that's not subject to the elective share would be pensions, profits sharing, stock bonus, deferred compensation. Think your qualified accounts, IRAs, those type of things would not be subject to the elective share. And then lastly, property passing by the decedent's exercise or non-exercise of any power of appointment. So when you think especially the life insurance and the deferred compensation provisions here, those are actually two big assets that would not be subject to the elective share. But assets that are passing through the will would be subject to the elective share. Now, when we're talking about blended families and planning for them, we always want to think about identifying the goals and priorities. So here are some questions that you should be thinking about. So number one, who should inherit specific assets? Might be you have specific parcels of real estate. We see this a lot with farming families or families that have multiple parcels of real estate. There might be certain parcels that a client wants to go to certain individuals. So you want to make sure that you're specifying that in your estate planning documents. You want to make sure that you're thinking through whether or not you want stepchildren to inherit anything under your estate planning documents. And if you do, then how much are they receiving? You also want to think through, do you want your spouse to inherit anything? And if so, how much? And then lastly, do you want to give your spouse the house? Or do you just want to give them a life estate? And I think this is a bigger question when one spouse owns the real estate, which I've seen a handful of times where maybe husband owns it or wife owns it, and it's not actually in joint names. And the one recently I had, it was a second marriage and the house was in wife's name. And the question was whether or not we were going to give the husband a life estate, or were we actually going to have the house go to the husband? And so we had to talk through that and then incorporate that in the estate plan. Here are some frequently asked questions when we're dealing with blended families. So the first is, how do I provide for my children from a previous marriage without enriching a new spouse? Number two is, how do I make the distribution of my assets as straightforward as possible? Number three, I don't want my new spouse's children or family to inherit my assets. How do I prevent this? Number four is, how much should I leave my new spouse to ensure they're comfortable without jeopardizing my children's inheritance? Number five, what if my spouse remarries after I'm gone? How can I ensure my assets stay with my family and don't go to someone else? Number six, are there tax implications of legal issues unique to blended families that I need to worry about? And then number seven, how do I ensure my assets don't end up in the hands of a nursing home? So let me talk a little bit about these frequently asked questions. So a lot of these can be answered by simply explaining that if you do a will-based plan, you do lose the ability to control what happens after you die for most assets that pass through the will. So when we're talking about whether we're going to do a will-based plan or a trust-based plan, it seems like more and more when we're dealing with blended families, we're leaning more towards a trust-based plan. And that's because you can do a revocable living trust where you're leaving assets to your spouse in trust. And when that spouse then passes away, you can then direct it to your children and not to stepchildren or other beneficiaries. So it allows you to benefit the spouse while still then controlling what happens to the assets. And that covers a lot of these questions here. One of the questions, though, is dealing with tax implications, number 6 here. And one thing I'll say about that is we're always worried about Pennsylvania inheritance tax and about who's going to pay the tax and the rate of tax. But there's another tax that we always have to be concerned about when we're transferring real estate, especially real estate into trust. And that's what we call Pennsylvania Realty Transfer Tax. And what's interesting is there's no transfer tax if the real estate passes into trust for stepchildren, but there would be a tax if it pays to step grandchildren. So if, for example, you do want to provide for your stepchildren and you use the language per stirpes, which means that if a stepchild dies, it goes down their line, then there would be potentially additional tax that you wouldn't have if this were a direct lineal descendant. So you need to think through that. And then the last question here about how do I ensure my assets don't end up in the hands of a nursing home? You have to understand that if you are married, it doesn't matter whether assets are individually owned or jointly owned, with the exception of retirement accounts. Any asset is going to be available for a spouse who needs nursing home care. So again, you might get married later in life, or it might be a second marriage, and you might want certain assets to go to your children. But if your spouse goes into a nursing home, those assets are in jeopardy to pay for nursing home costs. Okay, let's talk about some concerns. So common concerns, number 1, avoiding enrichment of a new spouse. So you can use a trust and you can make it so that it is a marital trust, and we call that a qualified terminable interest property trust. And this can provide income for your spouse during their lifetime. And then when that spouse dies, it would go on to your children. You can provide direct bequests. You can leave a specific asset or amount directly to your children to ensure that they're definitely going to get something when you die, even if your spouse survives you. And then lastly, you could always use life insurance. You can designate your children as beneficiaries of a life insurance policy to make sure that they're getting certain funds. The reason why that can be so attractive to families is life insurance is not subject to inheritance tax when other assets in your estate would be. Common concern number 2 is making the distribution simple. So I always want to leave your estate plan as simple as you can leave it because that makes it easiest to follow. So you want to make sure you're creating a clear will and or trust. Specify exactly who inherits what so there's no room for ambiguity or interpretation about what you may have wanted. You want to simplify your beneficiary designation, so making sure you're updating retirement accounts, life insurance policies, any transfer on death or pay on death accounts. And you may want to consider using a neutral trustee or executor, and that can be a bank, it can be an attorney, it might be your accountant. Especially when you're talking about blended families, it provides some neutrality there so that you can make sure that your wishes are being satisfied without worrying about creating conflict between your spouse and maybe your children. Common concern number 3 is preventing current spouses' children from inheriting. So this is a pretty common thing where, again, you might want to be providing for each other. We see this a lot with family businesses or family farms. The one spouse might say, well, I want to make sure my spouse is taken care of, but I don't really want any assets to go to anyone outside my family because maybe it's a farm that's been in the family for years. So they want to make sure that it continues on through the family. So you can do that with trusts that have some restrictions. So you can use a revocable trust to control where your assets go and prevent unintended inheritance. You can make sure to have a prenup or a postnuptial agreement that might clearly define what assets go to each spouse and their descendants. And then you can always use life estates, and this is where you're giving your spouse the right to use or enjoy a certain asset during their lifetime, but then upon their death, it would then go to your remainder beneficiaries, which might be your children. And that would allow you to then control what happens after your spouse dies. Typically, I tend to favor the trust option just because I think it's cleaner and neater than the others, but you can use any of these or you can use multiple of these at the same time as long as it's accomplishing your goal. Common concern number 4 is how much should I leave? That's always an interesting question. It kind of depends on how old you are when you're doing your estate planning and how much your spouse might have in their name. Now, I'm dealing with one couple that's doing their estate planning, and one of the things that we talked about is one spouse is significantly more wealthy than the other. And the wealthier spouse wants to make sure to provide for their surviving spouse. But the concern there is that if the surviving spouse uses all of the deceased spouse's assets and never uses their own assets, then it potentially would allow whatever that surviving spouse's assets to go to their children and then limit or reduce what would go to the deceased spouse's children. And so usually you have to put a priority on. So you might say, to the extent that my surviving spouse has exhausted his or her own personal assets, then my trustee can make distributions out to my surviving spouse for their care or needs. You can do that using a marital trust, which provide income or limited access to assets to your spouse while preserving the principal for children would be one option. You can use beneficiary designations on retirement accounts and divide accounts between your spouse and children using those beneficiary designations. And then lastly, you can go ahead and start lifetime gifting and give assets to your children during your lifetime so that way they have an amount. Maybe they didn't get it when you died, but they're going to still receive their inheritance. It's just at a different time. Common concern number 5 is avoiding enriching a new spouse. And you can do that using irrevocable trusts, because usually what happens there is then all the provisions are locked in. And so you can ensure assets are protected for the future spouse and remain going to your chosen beneficiaries. You can do spousal agreements, might require your spouse to waive rights to the trust assets in the event of a remarriage. So we see that commonly in trust where it says The spouse can benefit as long as they aren't remarried. And so that would then the remarriage would cut off any distributions from that trust. And then lastly, you can have restrictive conditions. You can include clauses in your wills or trusts that limit access to assets if your spouse would remarry. Okay, common concern number 6 is tax implications for blended families. So Pennsylvania inheritance tax, we need to know that Pennsylvania taxes assets that are passed to anyone other than a spouse or to a charity. So if it's to a child or to a stepchild, it's 4.5%. Stepchildren considerations, they do not automatically inherit unless you include them in your estate plan. So if you would say my descendants, under Pennsylvania law, that's direct lineal descendants, and it could include adopted individuals, but it's not including any stepchildren. So if you want to provide for your stepchildren, you need to either redefine descendants to include stepchildren or specifically bequeath assets to them under your estate planning documents. Federal estate tax exemption, the current exemption is $13.9 million in 2025, so you can always use that and gift assets, which would lower what your total estate is worth. And then lastly, trust planning. You can use trusts to minimize tax liability and control distributions across multiple beneficiaries or generations. Common concern number 7 is keeping your money out of the hands of the nursing home. We're seeing more and more couples concerned about this. I think as the cost of care rises, we're only going to see more people concerned about this. And it's a legitimate concern. How do you make sure to pay for nursing home care? And remember, if you're married and you've kept your assets separate, because maybe it's a second marriage and you each have separate accounts, it doesn't matter from a nursing home standpoint unless it's a retirement account. Regardless of how it's titled, a nursing home is going to use or avail themselves of those assets. So ways that you can protect against that is that you can do Medicaid compliant trusts. So that's what we call our asset protection trust or a Medicaid trust, and that helps to restrict assets and income limits for the Medicaid program and helps you qualify for those programs. Now there's a 5-year look back period when we're talking about these type of asset protection trusts. So that would be one way. Long-term care insurance would be another way. So that would be a traditional long-term care policy that you could purchase, and then if you meet the criteria, they would pay out. Benefit of a long-term care insurance policy is that there's no look-back period for that. The next category is irrevocable trust. And I'm thinking, as I'm thinking through this, the Medicaid compliant trust, I think what my intern put together in my slides, I think what he's implying there is actually a Medicaid compliant annuity. So that would be if you had one spouse going into the nursing home, you could take assets that would be countable and convert them into an income stream to the community spouse, the spouse that's not in a nursing home. And I think that's what he means by that. So that would be an option. The irrevocable trust is what I was talking about earlier. That would be a Medicaid trust that's subject to the 5-year look back period. But we have a lot of people that if you set them up and you transfer assets into the trust and those assets are in the trust for 5 years or longer, then they're not available for long-term care costs. And that's a great way to do it. And then lastly, gifting strategies. You can reduce your countable assets by gifting during your lifetime as long as you know it's subject to the 5-year look back period. Okay, let's do an example scenario. I think that's the best way to help people understand different planning strategies for blended families. So let's talk about this. So we have John Doe, and he's remarried to Jane. So Jane and John Doe is our couple. They have 2 children, Emily and Michael. Emily and Michael are actually from John's first marriage. And then Jane has 1 child, Sarah, from her previous marriage. John and Jane don't have any children together. And what John wants to do is he wants to ensure that Jane is financially secure if he would pass away first. And he wants to make sure his biological children, Emily and Michael, receive an inheritance from his estate after Jane would pass away. And then we want to make sure that Jane's child, Sarah, does not inherit from his estate as he's not her legal or adoptive parent. So the challenges here are balancing the interest. John wants to provide for Jane during her lifetime while preserving assets for Emily and Michael. And he hopefully wants to avoid potential conflicts between Jane and Emily and Michael. He also wants to protect assets, ensuring that anything he leaves for Jane would not be redirected to Sarah or Jane's other beneficiaries if Jane would get remarried or change her will. And then lastly, he wants to minimize taxes. He wants to make sure he's structuring the estate in such a way that Pennsylvania inheritance tax would be minimized. So the estate plan for John Doe, what you could do is you could set up a marital trust. So John could create a qualified terminable interest trust property for Jane. This would allow Jane to receive income during her lifetime, and upon her death, the remaining assets would be distributed to Emily and Michael. The benefit here is that it ensures that Jane has a stream of income or financial security. It prevents Jane from redirecting assets to Sarah or to others because this trust is irrevocable. So Jane can't make changes to the provisions and direct it to Sarah or to any other beneficiaries. And it does delay the tax on the trust assets until after Jane's death. And the reason because of that, or the reason for that, is that Jane is the spouse. So under Pennsylvania inheritance tax, there's no tax when it goes to the spouse. So inheritance tax would only apply at Jane's death on the assets owned in the trust. Actually, can you go back, Jess? The next one is direct bequest to the children. So John could leave specific assets like his investment account or property directly to Emily and Michael in his will, and that would ensure that they would get an inheritance immediately upon his death. Now, you have to keep in mind, remember, Jane can claim the elective share, so it's not like you can direct everything to the kids. You want to make sure you're balancing that. The life insurance policy, he can name Emily and Michael as beneficiaries on the life insurance policy, and that would make sure tax-free funds would go to the children without waiting for the estate to settle. John could also ensure that Jane retains full control over her own assets to provide for Sarah without relying on John's estate. And then updating beneficiary designations, John could update those beneficiary designations on his retirement accounts and other non-probate assets to reflect what he wants. So for example, instead of naming Jane outright, if he wants Jane to benefit from those assets, he could name the trust for Jane. That way she can receive it during her lifetime, but then if there's anything left over, it goes to Emily or Michael. He can also just designate it directly to Emily and Michael if he would want to do that. The outcome is that Jane receives income for her life, which would ensure her financial stability. Emily and Michael would inherit the remaining assets in trust after Jane's death, along with any of those direct bequests that he made and the life insurance benefit. This would allow John's wishes to be honored, preventing any conflicts or disputes between the different parties. So how do you do this and maintain a plan like this? So the first thing you need to do is make sure you're talking to your estate planning attorney, to your financial advisor, to your accountant or tax preparer. I always think of it as a team approach. You want to make sure you have all the team on board. Everybody understands what the mission is and what we're trying to accomplish, and then is doing it in the most cost-efficient way. Usually, if you have those financial and professionals around you, it can lead to a better estate plan. Secondly, you want to make sure you're having periodic reviews of your estate plan, especially coordinating the beneficiary designations with the will or with the trust. You want to make sure you're doing that. And then lastly, you want to make sure you're educating your family members about the estate plan. I don't like it when it's a big shock when someone dies. So if you can have open conversations with your family members about what you intend to do and why you're doing it, I always think it's better for the surviving spouse and for the children. Okay, so I wanted to remind you next month, March 13th at noon, our virtual seminar is Tax Hacks for Generous Hearts, How to Give and Save Big. So we're going to do that next month. It is March 13th. We're back at the noontime slot next month. My schedule was a little off today, so we had to move it a little bit later, but next month we'll be back on at noon. I will take questions once I stop recording, but I'm going to go ahead and close out our seminar for today. Thank you so much for joining us. This is Samantha Wolfe with the Law Offices of Samantha Wolfe. You're always welcome to call our office at 717-655-2676 to schedule a meeting. I'd love to meet with you and talk about documents in your estate plan. Today we were talking about estate planning for blended families, and I hope that you learned something. Like I said, call if you need any documents reviewed or if you have questions or concerns. Thank you so much for joining us. I really